Good morning or good afternoon to where you're joining us from. My name is Dan Johnson, and welcome to today's webinar. We're going to cover Odd Worker Out, Eliminating Workplace Bullying and Promoting Civil Communication. As a reminder, this webinar is being recorded, so if you need to hop off at any time, we will send out that recording, the slide deck, as well as the HRCI or SHRM credit in an email tomorrow. We would like to thank all of you for attending today, especially those that continue to attend each month's webinar. And I'd like to pass it off to our host, Britt Waterman, who is a senior attorney here at MyHR Counsel. Thank you, Britt.
Thanks, Dan. Well, it's good to see everyone here on the webinar today. Today we are going to talk about what is kind of a hot topic recently, workplace bullying, and then kind of how to manage the workforce so that we have civil communication, a healthy communication within the workforce. This is something that we see a lot, the attorneys see a lot. It is kind of, well, we've got this one employee, they're not getting along with the other employees, or, you know, we've got two employees, they seem to butt heads a lot, and what, you know, when does this cross the line and what can we do? And so this is something I hear a lot about. And so I'd like to talk more kind of about what workplace bullying is, when you might have a problem, when things are violating the law, and get to that point, and things you can do, how you can avoid harm to your business, and how you can promote a good workplace culture. So our agenda for today is to talk about some statistics about workplace bullying, to talk a little bit about your liability and how to reduce risk. And then we do have some hypotheticals, some scenarios at the end, which I know everyone likes, because everyone is relieved when it's not about their workplace. But other times people kind of see their workplace in the scenario and think, okay, what do I do next? So we'll discuss those at the end. So what is workplace bullying? It's basically repeated conduct from an individual or group toward a targeted individual or group, causing a negative impact on the target's physical and or mental health, and disrupting workplace operations and employee morale. So you can see it can take any of these forms, and it's kind of, it's very similar to what you remember from middle school bullying. It can be gossip, it can be rumors, it can be social isolation, it can be I'm going to invite everybody in the office to lunch except Linda. You know, that can be a form of workplace bullying. It can be work interference or work sabotage. I'm going to go ahead and come in early and do all of the payroll reports before Anne can get to work, and then it looks like I've done everything and she's done nothing. You know, it doesn't just have to be, you know, name calling or physically assaulting someone. It can be all of these things. So workplace bullying by the numbers, this is kind of some interesting statistics that have been put out. So 19% of Americans have experienced workplace bullying. So that's 1 out of 5 people in your workplace now, 1 out of 5 of your employees has been bullied in the workplace, as well as 19% have witnessed workplace bullying, and 9% are currently experiencing workplace bullying. So that's, again, about 1 in 10 of your workers are currently being bullied in your workplace. 70% of workplace bullies are men, and 60% of targets are women. This doesn't necessarily mean anything. It could mean that employees that are traditionally have more male employees have an environment that is more conducive to less civil conversation or behavior. It could mean that though in those environments have not fully been integrated by gender. It could mean a lot of things. It does not mean that that women can't be bullies. It doesn't mean that men can't be bullied. It doesn't rule out anything. And 61% of bullies are managers or supervisors. So that's something you've got to watch out for, is not just employees bullying each other, but managers or supervisors really taking advantage of their roles and bullying their own employees. So what are the effects on employers and employees? Well, it's not just kind of a dip in employee morale or these two don't get along. So, it's kind of a pain when one of them comes to the HR office with another complaint. 65% of targets, so victims of bullying, are terminated or quit due to bullying. And that quit can be what we call a constructive discharge, which is when somebody's work environment gets so intolerable that they have no other choice but to quit. And that can be called a constructive discharge. And that can be the same as a termination. So that can be viewed as an adverse employment action. That can be viewed as the same as if you were to terminate that employee. And 65% of targets are terminated or quit. A lot of times targets are terminated because they are the squeaky wheel trying to get the grease, and they get labeled the problem employee. The bully can seem very innocent on the surface, knows how to manipulate the system and portray the target as the one who's not cooperating, who's not going with the flow, and employees can get set up that way and end up being terminated, which is also an adverse employment action and can set you up for some discrimination or harassment issues, some wrongful termination issues, depending on the circumstances. 40% of targets suffer adverse health effects due to the bullying, and 22% of employees with adverse health effects say that this was apparent to other employees. So this is something that other employees are witnessing and seeing these bullied employees getting sick, seeing that the bullying is so bad that these employees are actually developing illness due to the bullying. And collaboration and help by coworkers is just not happening. Coworkers are not speaking up for other employees. They're not going to HR and saying, "Hey, this is happening to my coworker." So that's definitely something that needs to be worked on, is encouraging employees to speak up, but it's not something that's happening now. So effects, what are the effects on you to continue? You could lose good employees. Employees could also shift or transfer into roles where their skills aren't being best taken advantage of because they want to avoid the bully. You've got lost productivity and absenteeism, people missing work due to the negative health effects, people missing work just because they don't want to show up and be bullied. Again, poor employee morale. Employees who witness this, again, are not coming forward because they're afraid that it will happen to them or that they will be retaliated against for intervening. The whole thing creates a culture of fear and isolation in your workplace. And if you're the kind of employer who claims that you have a cooperative, harassment-free, employee-friendly workplace, and then something like this happens, employees are going to lose their trust in you, and their loyalty to you is going to suffer as a result of something like this happening. So a lot of employers will promote themselves as having a very employee-friendly company culture, and when something like this happens, it really destroys trust, and it really turns off potential candidates who may be considering your company as a place to work. This could shut that down really fast and make it hard to attract candidates. So hostile work environment. This is a legal theory. This is not just the idea that someone's behavior is hostile, as we know in the sort of non-legal definition of hostile. I used to see this all the time in my previous life. Before my HR counsel, I was an unemployment law judge, and I would deal with employees who claimants who had quit their job. And I would say, why do you quit? Why did you quit your job? And they would say, well, it was a hostile work environment. And because hostile work environment is a legal theory and only exists when there is discriminatory or harassment based on protected class, like sexual harassment, I would say, okay, well, what is your protected class, and what was the harassment or discrimination? Oh, well, there was nothing like that. And I would say, well, what was the hostile work environment? Well, Jan was really hostile. I'd come to work and she wouldn't say hello to me in the hallway, and she shared her birthday cake with everyone but me. That may be hostile, and that sounds hostile to me, but that's not the same thing as a hostile work environment. There's no law that requires employers or employees to be warm, welcoming, friendly, polite, helpful, or civil. 80% of workplace bullying is completely illegal, but that doesn't make it okay. So in a sexual harassment case, when we're talking about what a true hostile work environment is, um, a hostile work environment can refer to a work environment where employees view or display sexually explicit photos, websites, give each other adult-themed gag gifts, talk about their sex lives. When we're talking about a racial harassment case, a hostile work environment can be where employees use racial slurs, make racially derogatory jokes, talk about individuals of another race using stereotypes. So in order to establish this legal theory of a hostile work environment, you have to show a nexus between the behavior and the protected class status. So someone who is a jerk to both African American and white employees equally, a Black employee could not establish that because of to claim hostile work environment. So the person is just being unpleasant across the board. A Black employee could not establish that they are being unpleasant or rude to them because they are Black. Usually there's no hostile work environment when the bully is, like I said, an equal opportunity harasser. And we'll get into this in our scenarios. But if you have a bully and one group gets it worse than another group, there could be a nexus in that case. A hostile work environment, it must be severe and pervasive. So it can't be just a one-off comment that is inappropriate. It must be attributable to the employer, which means your employees have to be the ones doing it. And it must be abusive by both an objective and a subjective standard. So an objective standard is any reasonable person would look at this and find it abusive. A subjective standard is this particular victim found it abusive. So it has to be considered abusive by both by both standards. So potential liability, even if you prevail on a hostile work environment claim, workplace bullying can still be costly for you. Retaliation, if someone complains about discrimination or harassment and you fire or demote someone for making this complaint, they could prevail on a retaliation claim, even if it turns out that no discrimination or harassment occurred. So no discrimination or harassment needs to be found for someone to succeed on a retaliation claim if you took action against the person who made the complaint. Now, retaliation is the most common charge at the EEOC, and it is the easiest to win. So you really want to stay away from retaliation. That's going to be a lot of trouble for you if you've got an employee claiming retaliation. Intentional infliction of emotional distress, negligent infliction of emotional distress. These are tort claims. They're governed by state law. They're generally very rare, but they are possible. In order to succeed on these claims, generally the bullying behavior must be severe and outrageous and shock the conscience. So these are less common. The bullying behavior has to be very serious in these cases. Assault claims, that would be a physical injury from bullying. Generally, a physical injury from workplace bullying would fall exclusively under workers' compensation, but at least one court has upheld a jury verdict on an assault claim, specifically referring to workplace bullying. OSHA, you have a duty to provide a workplace free from hazards. This includes physical violence from other employees. If you become aware of threats or other indicators that violence may occur, you're not following your general duty under OSHA, and you have notice for potential from violence, you're violating OSHA. You need to be protecting your employees, making a workplace full of free of hazards. And then your experience rating, both for workers' comp, because again, this is an employee getting physically injured by another employee, is usually a workers' comp claim, and also an increase in your experience rating for unemployment. If you've got an employee who quits due to workplace bullying and you were aware that it was going on and you didn't stop it, the employee's probably going to get unemployment compensation if they file after they separate from employment, generally. So those can be liability for employers. So what are the positive outcomes of preventing workplace bullying? So boosting employee morale, protecting your business reputation is very important, improving employee retention, and reducing the risk of that liability we talked about on the previous slide. Happy employees care more, they work harder, they're more loyal, they take fewer sick days, they get more work done when they're not dealing with interpersonal issues in the workplace. Cooperation between employees improves efficiency and in the workplace. And employees with gripes and grievances with other employees are more likely to take to social media these days and complain about how they are being treated. You don't want your customers or clients to observe uncivil behavior or deal with employees who are miserable and lack confidence. You don't want this opinion of your company out there on the internet, or you don't want customers or clients to come in and see your employees just dragging around and looking at the floor and seeming to lack confidence and being unhappy. That doesn't do well for business. And previously discussed, even if the bullying is not based on protected class status, or it's not severe and outrageous, you don't want the hassle and expense of defending against a lawsuit. Plus, a retaliation claim can succeed even if the underlying claim of hostile work environment fails. Now, we tell our clients a lot of times it can cost $7,500 just to get you to the courthouse door. Now, that's without the attorney helping defend against a motion for, or helping you uh, file a motion for summary judgment, which means getting the other side kicked out of court, just to get, not even to try the case, not even to say your piece about, you're right and they're wrong, not even to get there, but just to get to court, just to have your first day in court can cost $7,500 to $10,000. So you don't want someone to file a lawsuit against you, even if you believe that you are absolutely 100% right. It's just not something you want to have happen. So an anti-bullying policy is something that every employer should have. This should be in your employee handbook. Again, it does 80% of workplace bullying is not illegal, but you should definitely set out your expectations of what is acceptable and what is unacceptable, so that employees know when they read the handbook where they stand and what is okay and what's going to lead to discipline or termination. Tennessee has a model policy. Again, this doesn't make workplace bullying illegal in Tennessee, but when there's no discrimination or harassment based on protected class status or protected activity. But when an employer in Tennessee adopts an abusive conduct prevention policy that meets specific standards, they receive immunity from lawsuits claiming negligent or intentional infliction of mental anguish. So in Tennessee, if you follow their model policy and put that in your handbook, or you have an abusive conduct prevention policy that meets these standards that the Tennessee law has set out, you put that in your handbook, you can get some immunity from lawsuits. So that's always good to, if you're in that state, follow the anti-bullying law. And you want to, when you're creating this anti-bullying policy, you want to define the workplace culture you want to create. So how do you want people to treat each other in your workplace? And what are your core values for your employees? That's important in defining that at the beginning of employment, just to set that out. What are your values? How will employees know when the line has been crossed? Well, you should let them know in the anti-bullying policy. Clearly define the unacceptable behavior so that employees know, if I do this, I've crossed the line, I'm going to be disciplined or terminated. It lets employees know when to report what they see another employee doing, when unacceptable behavior is clearly defined, and you're encouraging your employees to report harassment that they've seen happening to someone else, to bump the number up over that 1% who are actually reporting now. Instead, you should encourage that, and employees in a clear policy will know what specifically they should report. What should employees refrain from doing specifically if they want to avoid termination? And what should a victim unequivocally know? Hey, I don't have to shake this off. I know this is a hard no. This is something that employees can know. Okay, this is wrong. I know this is a no. This isn't allowed here, and I don't have to put up with it. So, process for reporting, you can have a several step process, such as, first of all, tell the person, no, I don't like that, knock it off. Then if that doesn't work, tell your supervisor. If the conduct involves your supervisor or you don't feel comfortable telling your supervisor, it can be any member of management with whom you feel comfortable. Tell HR. The complaint can be oral or written. HR and management should have an open door policy. You should make it very difficult to report illegal harassment or request an accommodation. The same should be true of reporting workplace bullying. It should be a very easy procedure. And just like reporting harassment, you should make those things easy for employees to come forward. You can be liable for retaliation, again, even if no discrimination or harassment is found. But you can make very, very clear that retaliation is strictly prohibited and will result in discipline up to including termination if someone is to engage in retaliation. The Healthy Workplace Bill. Now, 31 states have introduced the Healthy Workplace Bill. It has not passed, although Puerto Rico has passed a very similar law. There are just some slight changes to the Puerto Rico law. California introduced a bill, but ended up merging abusive conduct into their sexual harassment training instead. So no states have passed the Healthy Workplace Bill yet, although people are definitely working for it to be passed. This is not something that employees usually think about. This is something that employees kind of think about as a gendered issue, like I said earlier. But this is really for anyone, and plaintiffs can be anyone. This is not just for protected class individuals, and this is civil liability for abusive workplace conduct. So again, it doesn't make abusive workplace conduct against the law criminally. It creates a right of action for employees to sue their employers if their employers fail to stop abusive workplace conduct. They use the term abusive workplace conduct because they believe that the term workplace bullying kind of trivializes what is actually happening. So the proponents of this bill do use the term abusive workplace conduct. To prevail on a claim under this law, a plaintiff would just need to show harm. Harm can be emotional pain, adverse employment action such as termination or constructive discharge, health issues. Details are public. Employers cannot put a suppression or an NDA order in the lawsuits. If someone is sued under the Healthy Workplace Bill, it stays all public. California introduced this bill, but only ended up merging abusive conduct into their sexual harassment training requirements. So they added a little bit about abusive conduct into an already existing law, but that is the closest that we've gotten at this point to a state implementing the Healthy Workplace Bill. It's just not popular. I'm not sure why. Businesses don't want to get sued. So scenario 1, part 1. This is the case of Bob and Dave. Bob complains to HR that he is being bullied by Dave, his coworker on the line. Bob says that Dave tells quiet jokes to the other workers, and everyone laughs at Bob when he walks by. Again, this is a case of Dave inviting everyone to lunch except Bob. And Bob tells you he believes this is happening because he's gay. And you investigate thoroughly and you find out Dave doesn't know anything about Bob's sexual orientation. He dislikes him because he went to a rival high school. And you find that, Dave doesn't even know Bob is gay and has no reason to know. 1 week later, after this, Dave hides a tool that Bob needs to do his job. Now, is this Dave just being a jerk? and we can look at part 2 here, the response. Do we have the next slide? Okay, so is this Dave just being a jerk? That's wrong. So although your investigation finds that Bob is not the victim of illegal discrimination, this is not discrimination on the basis of sexual orientation, and that Dave's bullying, it's unprofessional and childish, but it's not illegal. When Dave hid the tool after Bob made the complaint, that was retaliation. Now, retaliation is illegal, or like I said, it's the most common claim at the EEOC and the easiest to win. And can we be won even if no underlying or discrimination or harassment is found? Another note here, your investigation found that Dave was not bullying Bob based on his sexual orientation because he had no knowledge that there was another of the sexual orientation and there was another reason for the bullying. When an employee of a protected class claims harassment and bullying based on their protected class, believe them and investigate thoroughly. If an employee of color's performance starts to suffer because they are being supervised by someone who has expressed racist views, your response is to have the racist super discipline them without investigating the racism. You're going to end up in trouble. So if a person of color complains that their supervisor is racist, it doesn't matter who it is. You should immediately investigate because you don't want to step into that can of worms and without investigating the racism and having the supervisor continue to supervise that person. Scenario number 2. So Susan is a manager. She will turn in 2 types of performance reviews, outstanding and terrible. You notice that a number of employees quit after Susan put them on performance improvement plans that are just unachievable. And while auditing your FMLA use, you realize that 8 of 9 employees who are on leave report to Susan. So when you ask Susan, what's up with the reviews and the PIPs, she says, well, she's motivating employees to improve and she's weeding out those who are wrong for the organization. So do you trust Susan to have the company's best interests at heart, or do you do anything? Well, yes, you do something. This is her behavior is not illegal again, but it is hurting your organization, causing high turnover, which costs your organization money, and responsible for an organization in medical leave, which is a decrease in productivity. This is sometimes hard to discover when your numbers or performance or production is good. It is harder to spot when the bully is a woman who has been promoted up through the ranks. Why would she treat people poorly when she understands what it's like? It can be impossible to spot when your policy's only reporting procedure is tell your supervisor, or your practice is to always have the supervisor and HR in on every meeting, and employees know they can never speak confidentially to anyone. So examine your company culture and see whether this kind of attitude is common throughout the organization. Is it every person for him or herself, and selling out other employees is just part of the competitive culture? Or is it you may pride yourself on retaining only the cream of the crop and pushing out those who can't take it? but is this going to backfire on you? Is this really what you're doing? Is this going to result in a lawsuit or a social media campaign against you, in addition to the negative impact addressed above? So, um, other Susan's employees may leave and you're ending up with turnover there, or one of them may stand up to Susan, challenge Susan, and Susan might increase her behavior, or she might harm herself, which either one is not a good thing that you want, is not something that's favorable for you. Scenario 3, Amy has been working in your clerical department for 9 years, and you just hired Sophia in an equivalent role. So Amy's annoyed that Sophia does not have the speed and proficiency that she has, and frequently takes work away from Sophia and says, just let me finish and I can do it faster. Now, Amy and Sophia's manager seems satisfied that all the work is getting done, but thanks, Sophia slacking on the job, she's not getting this done. You know, seems like Amy's doing all the work and Sophia's not doing anything. Should you, as HR, intervene? So yes, sabotage of work, I think like we brought it up before, is a common form of workplace bullying. So Amy is preventing Sophia from learning the skills necessary to do the job, and she's making Sophia appear less confident. Many companies have an Amy, the employee who has been there long term, knows the ropes, prides herself on her skills, and is threatened by change. I think everybody here can identify the Amy in their workplace, a loyal employee who cares about giving all of herself and her assets, or who cares about giving her all, thinks that's an asset to the company, but when she comes territorial, you've got a problem. So often an Amy can't do it all. She'll make mistakes, she'll burn out if she's doing the job of two people, even if she believes she is superhuman. So this territorialism needs to be looked out for and kept in check, because you're going to find yourself coming up short on work getting done and work getting done well. When a senior employee is refusing to train a junior employee because she is feeling threatened or intimidated, you're going to find yourself coming up short on work getting done and work being done well. So when a senior employee is refusing to train a junior employee because she feels she is being threatened, the only outcome for you is going to be poor work quality and high turnover because because she's feeling threatened. If your junior employees seem like they are underperforming and you suspect or you've got an Amy on your job, look for workplace bullying, because that's a good place to find it if you've got an employee like that. You should always, and like I said, it is necessary to dive beneath the surface. This may be a language barrier, it could be a disability, it could be if Sophia is a member of a protected class. Always be looking for protected class discrimination or harassment, even if you think that's not being allegedly or openly talked about. If you miss protected class discrimination or harassment, it's going to come back to haunt you. So just always explore that a little, make sure that that is not the case and what's going on. And scenario 4, Nick, the prolific Facebook user who is constantly sharing funny videos and photos of himself and his family and friends on his profile. So you've got Jake, an employee who is generally accepted by the other employees, but many of them look down on his activities and interests, such as dressing in costumes and playing role-playing games. So I think we all know this is Dungeons and Dragons, or LARPing, I guess they call it. hobbies such as this. So many employees consider this uh, kind of geeky, I guess. I guess I'm outing my own kids here, but some of the employees think that this is kind of nerdy for a grown man. So Nick has started posting jokes about it on Facebook, and he's not naming Jake, but he's mocking Jake's hobbies, and he's speculating kind of rudely on other aspects of Jake's personal life. So Jake hasn't complained about any of this. Do you get involved? And the answer is yes. So even if it's happening outside of work, workplace bullying is still a problem. Nick may identify himself as an employee of your company on his Facebook page, and his posts reflect that your company culture is contentious and not cooperative. You don't know how Jake is truly affected by Nick's behavior, and you want to step in before it leads to, as we've been talking about, absenteeism, poor health, poor performance, losing a good employee potentially who's going to prevail on his unemployment claim. I will tell you that. Um, Nick should be coached on his behavior, and Nick and Jake's whole team should be refreshed on workplace bullying and retaliation. Um, because I do believe Nick and Jake can get along. I just believe there needs to be some coaching here and some serious talk about workplace bullying and retaliation. So this is a situation where it's really easy to look the other way. I mean, it's happening outside of work. The bully isn't actually calling out the victim by name on his post. Everybody's generally getting along in the workplace. Jake isn't complaining. The jokes aren't based on a protected class status at this point. But this is a slippery slope. So Nick's jokes could cross the line into sexual harassment based on what he says about Jake's personal life. And this may be very surprising uh, to you, but a comment about a coworker's ability to attract a sexual or romantic partner, for example, are sexual harassment. And so if we're joking around, if Nick's joking around about Jake's hobbies and is making comments such as, people who stay home playing Dungeons and Dragons will never get a girlfriend, or may never find a lady or woman to kiss him. This is sexual harassment, saying things like that. And so that could be a problem for you and a risk of liability for you if things start to go that far. You don't want Jake to take matters into his own hands and settle things with Nick. This could end up being a lot of lost productivity at best and escalate to verbal or physical violence at the worst. So I would say you do want to intervene here. You want to just coach everyone. Hey, this isn't civil communication. This is this is not what we expect. No workplace bullying matter is too big or too small, and your employees need to know that the expectation is that they act professionally, civilly, and cooperatively on and off your premises. If they don't seem to know what this means, then you need to coach them on what this means. Scenario number 5. So we've got Dr. Ellis, who is a perfectionist, and he rudely criticizes fellow employees who do not live up to his standards. I think we've all maybe worked for someone like this. Dr. Ellis loudly points out the flaws and mistakes of all of his fellow physicians, as well as the medical assistants, receptionists, and nurses. Dr. Ellis refuses to speak to or work with the employees whom he deems unqualified and incompetent. Employees in the clinic are being reduced to tears when Dr. Ellis has seen them doing something wrong or something he perceives as wrong or inappropriate. So Kayla comes to you with a group of female nurses and medical assistants. to complain about Dr. Ellis's behavior. Kayla tells you that they feel bullied and harassed by Dr. Ellis, that they dread coming to work, and that some of them have begun suffering health issues. Now, they believe this is gender-based harassment. So, is this gender-based harassment? It depends. So Dr. Ellis is, again, going back to the term of an equal opportunity bully. If Dr. Ellis bullies everyone in the clinic and makes no distinction between race, sex, age, national origin, or any other protected class, Dr. Ellis's behavior, while extremely unprofessional and generally unacceptable in any workplace, is not necessarily unlawful harassment. It is notable that the group who came to complain about Dr. Ellis's bullying was a group of female employees. Not all physicians are men, and not all nurses and medical assistants are women. In this scenario, we can presume that Dr. Ellis was bullying male physicians and male nurses as often and to the same degree as he was bullying female doctors and female nurses. It is possible that a business can have more women than men, or that a business can have more employees of color than white employees, or more employees over 40 than employees under 40. And the bullying may have a disparate impact on members of a protected class. So it may be based on the makeup of your workforce that the bully has more victims in the protected class than not in the protected class. So this is something to watch out for. The equal opportunity bully defense is real, but you have to look at the actual makeup of your workforce and the actual impact on your workforce that is happening. So how do you maintain a civil workplace and free from workplace bullying? The first thing is establish a clear policy and train your employees. Like I said, Tennessee has that model policy that they've been falling back on, and that's a great policy, a great place to start if you're unsure where to start with a policy for workplace bullying. If you're a subscriber, please open a ticket, and we will help you with a policy. If not, I'm sure if you look on the internet, you'll see many samples of workplace bullying policies. I believe it's the Workplace Bullying Institute is the expert. They had the information about the Healthy Workplace Bill. I'm sure you can find a template there. Take reports of bullying seriously, get involved quickly, and investigate thoroughly. Treat these reports of bullying as you would reports of discrimination or harassment or a request for a disability accommodation, because something's got to change, or this is just going to snowball, and you're going to wind up in so much trouble. So you want to wipe out bullying right automatically. Prohibit retaliation. Again, most common claim at the EEOC and easiest to win. You don't want anyone to retaliate for making a complaint or participating in an investigation, whether they're going to win on the sexual harassment claim or other discrimination claim. That's not going to matter. Retaliation is its own separate claim, and you want to prohibit it. And finally, look past the surface to really see workplace bullying, and protect your employees and your company culture. You don't want to become known as the company where that's impossible to work, because employees are backstabby and supervisors are backstabby, and there's no good place to work. So look past the surface, look for that protected class status that might be involved, and look and see how your employees are really treating each other. And along with that policy, that's going to be the best way to maintain a civil workplace and avoid that workplace bullying. I don't have any more. It looks like we've ended about 10 minutes early. So if you have any questions, please open a ticket in our Ask system. If you recognized yourself in any of those scenarios, and open a ticket and have a response by the end of the day. Or if you're not a client of ours, please info at myhrcouncil.com, and we would be happy to discuss our packages in more detail with you, and explain more about our Ask an Attorney portal. These issues can be very tricky with, what is illegal, what is legal, where is the line, how do I draw that line? How do I figure out, what is going to lead to liability? These are very touchy issues. So, having us on your side is very important. And I recommend opening a ticket or contacting us at the email here if you have any questions about workplace bullying. So thank you all for attending today.
Thanks again, Britt, and thank you to everyone for attending our webinar today. Please be on the lookout tomorrow for the email with the recording, the slide deck, and then as well as the HRCI or SHRM recertification credit if you do need those codes. We look forward to having you again for our next webinar here in November, and have a great rest of the day.